Are we doing what's best? So, for all that, employee handbook, the best practices. Today, what we're going to go through is why the employee handbook matters. I know that there's several clients that we have that will say, I've been in business for X number of years and I've never had an employee handbook. Well, we're going to go through that and say, talk about some pros of having that employee manual. We're going to talk about some key elements. So I'm basically just going to share a list of these are things that you should include, and hopefully you do have it included. We're going to talk about the writing style and the organization of the handbook, which is really important because it's just not about getting the information and regurgitating it on paper. You want to make sure employees are reading it and kind of the benefits of doing it very well. Unfortunately, we will talk about a very boring topic, which is the legal compliance aspect of it. But hopefully, once we get through that part, I'm going to go through some common mistakes and I have some visual examples for you. And it's instances that unless you've had to defend a handbook in court or arbitration, you may not even know that there's an issue with it until you see it. So I hope everyone's excited. So why does the employee handbook matter? For the employer, there's some really key benefits, right? So you have consistency that's created for the policies that you have for the company, procedures, and the expectations. Sarah, if we employ you, this is what we can expect from you. This is what you can expect from us. So it's consistency on both sides, right? You having that handbook shows that you're not having favoritism for an employee. Now, once again, whether or not your managers and supervisors are following through with that may be questionable, but at least it's written down on paper that for the for the main part that you are going to treat every person that walks through that door as a person and they all have the same rights. You want to show that you have the willingness to comply with employment laws. I know for myself, and I know you might be all in different states. I'm in New York, which also explains my fast pace talking. But for us, like we have paid sick time for here. So it's one of those things where we accrue it 1 hour for every 40 hours worked. And I know there's a culture on Reddit that will tell people you're in a state that has this. Look to make sure that they have it included. We have this debate a lot is if you are in a state that has the paid sick time and you have PTO and you kind of combine them, you still have to list the rights, right? So if I work for Assure. So if Assure gave me a handbook that says, our PTO policy is also applicable with the New York State paid sick and safe law, which states employees can use it for the following reasons. That's an employee right. We need to know that. So by them putting it in the handbook, it shows that they are complying with the law. They're not trying to kind of like, sweep something under the carpet by just saying, well, our PTO is, superior than what they want to offer. So we're already doing that. It's like, okay, if you're doing it, just put it down. For the employer, it will also outline expectations for conduct and reporting procedures. So if something happens, and you want to highlight that inclusive environment, we have had events where somebody will leave their employer and it's because they felt like they were discriminated against or they were in a harassment, like a harassing workplace, but they felt that they couldn't tell anybody. And then they end up leaving, so basically resigning their role, and then they still go to the Department of Labor and make a claim. So it's really important because an employment attorney is going to say, hey, was Sarah aware that she was able to file a complaint with you, and what are the necessary steps for that? The other more positive side of it is that it really does. It'll communicate the company's mission, culture, and values, reinforcing the brand for the employee engagement on day one, right? If I come and work for your company, do I know what it means to be a part of it? Or are you just telling me the do's and don'ts of my role, right? The more that you can show that there's something beyond just the name on the door, it's it's nice because the employee should see that in every aspect. I know we talk about this a lot too, as HR professionals, is that I want to make sure that if a company has core values or a mission statement, whatever it is, or pillars, You need to replicate in every step of the process. Have it as a part of your onboarding or your recruitment. Big companies do this. Amazon, Google, they have it. They have what their core values are. Their questions are based on it. Then when you get hired, the employee handbook is also shaped to replicate that, to understand these policies follow this core value, follow this pillar that we hold very dear to the success of the company. Then it should be tied over into the job description and the performance review. But if you skip one of those steps, and oftentimes it is the employee handbook that people think, well, we'll just put it in our job posting and then in the job description, you're missing that linking piece, right? That employee handbook is just reinforcing, hey, we talked about this during the interview process. Now you can see what it means and how we feel like it is demonstrated in our company. Um, it's just, I don't know, as an employee, it makes you feel like you're not just a number, you're part of something that's bigger than just the name outside the door. So that's going to go into the employee benefit side of it. Is as an employee, it's giving me clear, concise guidance on expectations, conduct, safety, and company property. It it's I've been doing HR for quite a long time. So sometimes there are these things where when you're issued company property, whether it be a cell phone or maybe a computer, maybe it's a company car or a credit card, the ways that employees will try to utilize the company property in a way that it was not intended surprises me. You want to make sure that if you have something that the employee clearly knows, here's the expectations of you having this and having the company's name attached to this. Um, just in case that employee turns out to not do things accordingly, you at least have a reference to say, listen, Sarah was aware of this. Not only did she sign off on the separate policy, but we do have the expectations laid out in the employee handbook. You just want that reinforcement. Um, it should inform on compensation, benefits, and leaves with clear transparency. Sometimes people don't know what they can apply for when maybe certain scenarios coming around, and sometimes it's also personal. So you don't know, you may not know what you need to ask for. So if Chris is my supervisor and I don't know if I can take a leave of absence due, this is a very extreme example and I apologize, but maybe I'm a victim of domestic abuse and I am not aware of in my state because there are certain states that allow that, but maybe I don't want to bring it to Chris's attention. I might be embarrassed by that, but if I can see it in the handbook and it's very clear what I have to do, then I can go through that process. Because we also never want to put managers and leaders or someone who's wearing the HR hat in that uncomfortable position where you know too much about the employee and then all of a sudden we become sympathetic rather than empathetic, and that's a very gray line to walk. Um, we also want to foster independence for our employees. I know for us, what's coming up is Veterans Day and Thanksgiving. When I worked on site, it was a very common question, and my response, which looking back may have been a little sarcastic and probably should was not the best, would be, you know what? I wish there was a book that outlined all of the holidays we had and when we were not working. And they know it's the employee handbook. Typically, you'll list it in there. You also want to know too, you might have specifics because this is going to go along with like the clear and concise language, is that if you have a policy where someone works hourly for in order for them to get their holiday pay, they have to work the day before and the day after, or have it compensated with some type of PTO time, you want to make sure that that's clear and concise and that I know that. Because you don't want me to call in sick the day after Thanksgiving and then come to you and say, how come I didn't get paid for my holiday? It should be very clear and apparent to everybody. Um, and once again, the culture aspect that I was just talking about for the employer benefit, as an employee, I should know, hey, this is the culture that they're trying to create. And we'll talk about it when we talk about the writing style, but it should be apparent to me what type of environment that I'm also walking into. Any questions as of yet? Or are we good?
We're good right now. No questions yet.
Okay, awesome. So key elements. Okay, this is when you guys are going to get the list, and I don't want anyone to have a panic attack in case that you don't have it on there. But here are things when I look at a handbook that I'm looking for to make sure that it's included. I want to see if you have the introduction and a company overview. Who are you? What is the company? What is this? What am I about to be a part of? I want to make sure that there are employment policies. Basic one is the at will. Unless you are in the state of Minnesota, you are an at will state, and it's an employee right to know that you are in an at will state. Um, what people will do as a mistake is they will put that at will policy in an offer letter. And I can tell you, an employment attorney is going to look at that and say, well, when you offered Sarah a role, you were already planning on terminating her because you put the at will process in the offer. For some reason, people will put termination clauses, and unless it's a very contracted position, best practice, do not put that you require a 2-week notice if somebody is leaving in the offer letter, just from past experience. You want to have workplace standards and conduct listed there. Any compensation and benefits. So when I'm talking about compensation, it's more like pay cycles, right? So letting them know that you get paid like what your work week is, because that is important for overtime rules. So most states will look at the 7 consecutive 24-hour period. So if you say that your day starts on 12:01 Sunday morning and ends on 11:59 p.m. on Saturday, that's what you consider a work week. You want to put that down, and then you want to let them know when they're being paid. You can also put that in an offer letter. So as long as an employee is being informed of that, you're hitting that compliance piece. Um, benefits, when I mention benefits too, it may not necessarily be, I'm not talking about medical insurance, because those change from time to time, but what are the perks of working for you? Is it something where are you giving like education reimbursement? Are you giving reimbursement for other aspects? Do you provide, I know I work with a couple of real estate companies, so they'll provide seminars for people. So that's the type of stuff that they want to see. And you want to make sure that it's spelled out. So once again, if you're doing it for one person, I mean, you can isolate it to a position, but as long as everybody who has that job is able to do that, that's what you want listed. Because once again, you don't want it to appear as favoritism as, well, I really like Sarah, so I'm going to let her go to the seminar, but I'm not going to let Chris go to it. You just want to avoid it. Any time off and leave policies. So paid time, like sick time, if you have personal time, any type of leave policy. So if you are in a state that has your paid sick leave, or if you qualify for FMLA, if you have 50 or more employees, it's really important to have those things listed. Performance management and discipline, do you have some type of semblance? Are you telling people that, you're going to be evaluated on an annual, semi-annual basis, whatever it is, so they know and they're not shocked by it? Disciplinary procedures, it's up to you. I look really just to see, do you have some type of backing um for that one, I'm really looking at, do you have a no call, no show or no call, no show policy, which basically says, as an employee, if you no call, no show for 3 days, we will accept your voluntary resignation. And it's very important that you have that. And then you want to have maybe some exit, like the returning of property, and then the acknowledgement. I have read and understood this handbook. Once again, best practice, have that acknowledgement either as a separate document after the handbook or in the back of the handbook for the paperwork. I've seen clients where they'll put it like on page 2, and it's just low hanging fruit for an employment attorney to say, well, you're making Sarah sign this on page 2. How do you know she's going through the rest of it? Right? Worst case scenario, you put it in the back. Sarah's at least flipped through the handbook to try and find the acknowledgement piece of it. Okay. Hopefully everyone has that down. Let's get into the writing style and the organization. This is when you really get your chance to convey what type of company you are and your culture and almost like the personality of your company is kind of, it kind of comes out for in that handbook on that day one when that employee sees it. So you really want to have the clear communication and the understanding. You want to avoid really complex legal jargon. I've seen very complex policies for things, and it looks like it was copied straight off of the law that it's put in there. You want to make sure that it's pretty simple and straightforward so you don't have the confusion of what the policy is. There are policies in handbooks, and the Department of Labor is very good about saying this needs to be stated as it is listed, right? The paid sick time is one of those because they need to know in every essence when they can use it. It's okay too if you want to lump in, like, because some states have the civil air patrol service leave. Like I said, I mean, there is a domestic abuse one, there is jury duty, bereavement, all these little small indicators. And it's up to you if you want to list how you want to list them out and then the verbiage you want to list for it. And you want to make it pretty accessible. I just want to make sure you're doing it the right way because sometimes people will be very prescriptive, like when it comes to bereavement leave. Um, of indicating who accounts for family, and I get it because you don't want people taking bereavement leave for everything. It's one of those things where use the resources available, look at if there's current cases in your state, and make sure that no one's going after their employer because they didn't allow them leave for bereavement for a certain aspect of their life. So, we see this all the time. Same thing too is if you require documentation for a leave, it's crude sometimes to ask for it, but you are allowed to say, Sarah, this is the third request for bereavement leave this year. We just need some, documentation, right? Like the card from the funeral or the posting. Hopefully you're not in that area because someone's abusing that policy. But once again, with over 20 years, I've seen these things, and it's sometimes it creates a very uncomfortable situation. Use enhance accessibility and usability. Um, Visual aids, like the visual elements of it, make sure it's very clear. Use nice separators between the expectations. I do like when people will have handbooks and it's broken down by sections. You can tie those sections to your core values and your mission statement. When I work with clients, typically I'll help them create a digital version of it also. So your table of contents actually has the hyperlink. So if I'm in section like 5.2 paid holidays and I'm an employee who wants to know what I get paid for, I can open that digital document, click on that hyperlink and go right to the page and it's telling me exactly what it is. Because you want to work smarter, not harder for it. So if it means that in a digital world, people have access to it, a lot of times that hopefully they are fostering that independence and going to the handbook and trying to get the questions answered themselves before they come and ask you. You do have the chance to promote the positive tone and engagement aspect of it. Uh, it's one of the it's funny because I've been in this consulting realm now for about 5 years. When I read a handbook from an employer, a lot of their handbook reveals what type of employer they are, right? Like if they're an employer of choice, or if they're very strict, or if it's one of those things where they kind of fly by the seat of their pants and the rules are whatever way the wind is going that day. You really have the chance with your employee handbook to make it known that you will respect people, right? And respect is earned. That's why you have code of conduct and standards in a handbook. It's not guaranteed on day one that we will respect you as an employee. We will respect you as a human being. Those are two different aspects. But we want to make sure that you know what it means to be a part of this company and what values that we hold to and the expectations. And we do that by fostering inclusivity and letting you know, hey, we're all adults. We can be held to expectations. And here's the framework. Here's the rails that we have put on there. So if you can say that in a handbook, hopefully your employees actually will read it and understand it and say, okay, now I know what it means to be a part of this company, right? I always use a reference. My 16-year-old daughter, she got her first job this summer. She works for Wegmans, and if you are unfamiliar, it's a very large grocery store chain um, that is constantly on like Forbes and Times top list for employers as voted by employees. And she hears what I do for a living. So sometimes we'll be bonding and, watching a movie on the weekend, and I'm going through an employee handbook for a client. And when she did her onboarding, she actually came home and she was like, Mom, I actually read the employee handbook. She goes, I know what it is. She goes, I mean, she tried to kinda do a backhanded compliment towards me. She's like, "Now I know what your job is," and she goes, "There is a lot of stuff." She's like, "But I think I get it now," and I was like, "Okay, well, we'll see." But I'm glad that she went through it, and I think she's definitely the type of kid that, if it wasn't easy and digestible, she probably wouldn't have read it. She probably would have just said, "Okay, I'm just gonna have my mom read this and tell me what it means." But it's nice that Wegmans is following through with their commitment to their employees by making the onboarding and the employee handbook something that people can actually get their questions answered. The other part of it is making sure that you have that legal and practical balance. There's not a lot of creative license when you do have an anti-harassment policy or a discrimination. That's definitely one of those policies that you want to make sure that you have the verbiage down correctly. But that doesn't mean that you can't soften some of the words in that policy. Make sure that you're just covering the legal aspect of it so people understand. Oh, this is the not fun part. The legal compliance part of it is, but I just want you guys to be aware that there are things that when you do have an employee handbook, here are the things that like Department of Labor looks for. And once again, there is that subculture on Reddit where they will tell people, hey, if you get onboarded at ABC company, see if they have this in this handbook, because otherwise, they're violating something. And whether or not the claim is true, you still don't want the Department of Labor looking at an employee handbook and then showing up and randomly wanting to look at everything, because it's not like OSHA, where OSHA can only come and look at the one violation that was reported on. The Department of Labor is like, well, we've gotten some complaints, so we need to look into some things. And you definitely don't want a full audit triggered because something was missing. So some of the things that you're looking from a federal and state employment law aspect is the equal employment opportunity. It's up to you too, because it's one of those things where you can also put it on your job postings. If you're not hiring that frequently, it's a good idea to also put it in the handbook, which basically says, you're an equal opportunity employer and that you will take any qualified candidate regardless of these other protected classes. The anti-discrimination policies, I mean, one of those things that you're a company that will not tolerate that. And the same thing with the harassment prevention at the bottom of the page is, once again, you want to make sure that people know that it is not okay to act in that way and where they can kind of go in case they feel like their rights are being infringed on. The at-will employment is also important. You want to say that at any time the employer can end the relationship and the employee can end the relationship. Sometimes, and I have an example for this, so a visual, it has to be clear and concise, that aspect. At will is one of those policies where if I decide to leave my job today, my employer can actually not mark me as non-rehirable because I did not give a 2-week notice. A 2-week notice is an operational policy. It is a courtesy for an employee to give you a 2-week notice when they are leaving. At will, which is my employee right, states I can end the relationship at any time. So when someone puts somebody as non-rehirable because of just lack of notice, that's not okay. You're actually violating that law. Um, the other part of it too is making sure that if you do qualify for FMLA, that you have that lined out. And it's very important that people understand that FMLA is not paid. The Federal Medical Leave Act for the family is unpaid, it's just job protected. So you want to make sure that that's very clear and that they understand that they have to hit that minimum number of hours. I've seen this a lot of times where I'll have a new employee that comes in, they might be 3 or 4 months into the job and they tell me they're going to take FMLA. And I'm like, you haven't hit the requirement. You have to work 1,250 hours in the course of the week in order to qualify for it. So, um, once again, it creates an uncomfortable conversation because what does that mean if they have something going on? And that's when we look at more, the next slide will have like that local leave. Then you're looking at, well, what other policies did we have around that? Any wage and hour policies, you want to make sure that they're listed. And then the disability accommodation. So if something happens during the course of my employment and I now need an accommodation, they need to know how to go about that process. So local and state specifics, the paid sick leave, we want to make sure that we're entering that. Even if you've combined paid sick leave with your normal PTO, you want to let them know this satisfies the requirement of the New York State paid sick and safe leave. That verbiage needs to be included in there. It's also interesting because then it's a it's a conversation that HR professionals that we have all the time is, okay, if I've combined this with my regular PTO system, but Sarah calls off for 3 days, it's the 4th day that I have to ask for documentation, but you know, because it's combined, I can't penalize Sarah for not getting prior approval because technically it hits the sick requirement, which means Sarah can take the time off and I can't ask the reason. So you get into like those nuances. So it's really important for how you list those policies and also train your managers on it. Um, Minimum wage for your local and state areas might be listed. It's only if you don't have your labor posters, like those big giant posters that you put into your break room. If you don't have it listed somewhere, this is a good opportunity to follow it, although you are going to have to update it annually as it changes. Any type of labor regulation. So if you have child protective labor laws in there or anything listed, you would want to include it in the handbook. And then excuse leave time. So maybe you're in a state that doesn't have paid family leave, paid sick leave, and you don't have 50 employees, if you allow people to take a personal leave of absence, you want to list it out, right? And you want to make sure that you're validating the reasons why. You don't want to just say, well, Sarah asked for it, so I gave her the time off, but Chris asked for it and we said no, right? You want to make sure, is there a process to apply for a personal leave? Like, make sure those things are listed in there. So you don't I've had this happen too, where you have an employee who doesn't understand the leave laws, and they come in and they're like, "Oh, I'm gonna take the California Family Rights Act leave, but I'm gonna make it start tomorrow." And you're like, "Okay, did you apply through the state? Did you do these things?" And they're like, "Well, no, it didn't say that in the handbook." And you're okay. Well, let's walk this back a little bit. It's a learning experience for the employer and the employee, but we're there. Um, yeah, just use it as a foundational point. And it's okay also to put, if you have any further questions, please ask and put whoever the company contact is to ask about that particular leave or that process if it's more comfortable, because then you might have the paperwork listed there. Some legal safeguards, you do want to have an acknowledgement, making sure that they sign off and they understand the policies. You do want to review it regularly. There are changes that happen from time to time, and sometimes people will only, so if there's certain changes, I've seen client handbooks where you can see the original version and then they'll put the revised version. I don't know why you would have the old policy next to the old policy. I would take it out. But the other part of it is sometimes people only change like the legal side of it. So for example, the definition of harassment has changed from state to state, and I was reviewing a client's handbook which hadn't been updated. I mean, it had been kind of updated since 1997, but when I got to the dress code, because dress code isn't regulated by an employment law, they still had as their dress code that it was business casual. Men had to wear slacks, ties, sport coats, button-down shirts. certain shoes, all women were expected to wear skirts or dresses that were at knee length, or the shortest allowed was 1 inch above the knee. So I'm like, I'm going through the entire handbook, and you can tell that they've done a really good job of keeping up with the employment law. And then I got to the dress code and I asked the owner and I said, "Are you still following this dress code policy?" And he was like, "Oh my gosh." He goes, "We never even look at that because that's that's not what we were notified in the news." He goes, "That's so old." He goes, like, "Honestly, I don't even know if that was written in 1997." He goes, "I think that might have been from before that." And I was like, okay, well, let's change that. And I go, also, I'm surprised that no new hire has ever said that to you. I go, which is also a concern because that means they don't even get to the page with the dress code. They're like skipping over it, or they've shut down. Their brain has shut down from the legalese that you have, and they're just like, I can only, take so much in my human brain. I don't want to hear any more negative aspects of it. And he got a good chuckle out of that too, because he was like, "That's a good point." He goes, "I feel like I want to do a quiz now and see and just start asking my supervisors how come they're not holding people accountable for the dress code." So it was kind of, I don't know, us HR people, we have to look for the sense of humor in some things. You do want to avoid the ambiguous or contradictory language too. So I've seen things where policies, it'll state one thing and then the next sentence is the exact opposite. So you just want to be careful. And it happens. It happens when people try and edit their handbook on their own, and they might be wordsmithing something and put it right next to each other, but then when they go to finalize it, they forget to take it out. Also the limitation of liability disclaimer. So if you have a public space, if they're parking somewhere, just kind of those little nuances of that the company is not responsible for, damages to the vehicle if you're parked out front in the pub, just that type of stuff. You also want to make sure that you're using it for employment law purposes, and um try to only stick to that. You really want to make sure it's stuff that's backed by employment law. Okay. Now that we got through the legal stuff, let's go through some common mistakes. We kind of talked about this along the way, but complicating language is one of them. If it's something that somebody doesn't understand, I've seen an employment attorney kind of pick it apart. It should only contain the necessary information. So if don't include an FMLA policy if you don't have 50 employees, right? Because then what happens is somebody thinks that that person should have that leave. I've had this too, where a client approves somebody for FMLA, and I tell them, how is that possible? You don't have 50 employees. And she said, well, we just had it in the handbook, and I didn't want to tell them no. And it's like, okay, but now every employee can come and ask you for this. And yeah, it's just interesting. Leaving out vital policies. So here's some examples of policies. I wanted to add one too that I forgot is hopefully no one has a probationary period policy also. That's one of a big area, because all you're doing, the reason why I remembered it is because at will. Probation is just at will. If you tell somebody that they are subject to a probationary period, it's actually fraudulent. It is not backed by any type of employment law. And the reason why I mention that is because on the East Coast, quite frequently, an employer will get sued for triggering somebody's mental health because Sarah has gone through 4 rounds of interviews and she's been given this position, and now you're telling her that it is probationary and you put a cap on it at 90 days. So you've triggered something in Sarah, and Sarah feels like she is no longer safe. All you're doing as the employer is practicing your at will employment, right? I am able to end this employment at this time. Now, unions and civil service positions are different. They truly do have a probationary period, but it's not going to be in the company manual, right? That's a different scenario. So, a lot of employers will use this as well, we have a 90-day hold for PTO, for benefits, for 401, whatever it is. Just list those on those policies. If you have a PTO policy and Sarah as a new hire is not allowed to take PTO until 90 days, put it in that section. To tie it to a probationary period is something that you don't wanna do, because probationary period is also gonna trigger some other aspects of, are you informing somebody of how they're doing throughout their job, or are you telling them on day 72 that they're not gonna hit the probationary period? Employment attorney is going to eat that up. How were you rating Sarah? How did Sarah rate to other new hires? What is the scale? What was her learning curve? Were you providing constant onboarding and training? So, sorry, this is just a big, please don't list a probationary period in your handbook. Just put the at will process. Non-specific PTO. So when people don't actually detail if they have an accrual process, if it's front loaded, if it's rollover. Sometimes people will allow people to contribute to a bank of time too. So if they're in an area where they don't have paid leaves, they might have it as a bank. So if Sarah needs shoulder surgery, she can apply through this donated time. So those are some of the things that you want to detail out. If you don't let people know, because once again, I said FMLA is not a paid leave of absence. Employees are allowed to access their paid time off during FMLA. So if you allowed me to roll it over and I have 6 weeks of vacation time, I'm allowed to use that with FMLA just to make sure that I get paid, or if I'm not using a short-term disability to get compensated. Unintended loopholes. This is a big thing too. The Yes, you want to train on new policies and make sure that people are up to date. The one I really want to focus on is like the using common sense in social media. This gets played out in court and in arbitrations quite frequently. For social media, you want to be careful of what you're actually trying to police with the social media policy. There's a difference between someone having a public profile versus a private profile. If they're tagging their employer or if it's listed on their bio, that they're associated with this company, then you're looking at, do they get tagged from somebody else? Like, there's a lot of unintended loopholes. So when an employer decides to discipline or terminate based on a social media policy, um, it's very difficult because what the court is going to rely on is the verbiage that you use in your social media policy. And typically, the one that people will copy is just that while you are at work, you are not allowed to be on social media devices and you're not allowed to tag the company. And that's it. What they forget sometimes is that, am I attached to that, right? Did I put that I work for Assure, and then did I comment on a different post? And there's so many nuances to that. So if you don't know what it should be, please ask, reach out to Chris. We want to make sure that you understand what you're doing when you're trying to kind of look at that. The other aspect is common sense policies. HR exists because this coffee is hot, right? Common sense is a subjective trait from person to person, and it's based on experiences and education. So, when you have an attendance policy that somebody says, use common sense if you are not coming into work and let your supervisor know, you're not giving detail, right? Am I letting my supervisor know before the shift, after the shift, 2 days later? Don't use it. It's, once again, because if it's going to be brought in front of somebody to decide, it's going to go to a jury of peers or an arbitrator who doesn't care about the backstory of what Sarah did, right? If Sarah violated this policy, the arbitrators or the jury, they're going to go to what's written in that handbook and what's being upheld through the managers. Um, the last common mistake before we get into some examples is, please do not copy an old handbook. If you come from a previous employer, and you're like, "Hey, I'm helping my buddy with this small business. I'm going to copy this." Just don't do it. There's so many risks associated from like the legal and the compliance part, that you could have legal infringement too. So if there is a policy that's specific to a company, or they find out that you've copied it, like that, there's you could face lawsuits from that way. Also, an employee is gonna know. Like, when I see handbooks and there's different fonts and some of it is editable, but some of them looks like it's screenshot and pasted there. It's like you didn't take the time to show me you value me as an employee or value yourself, right? As an employer and say, here's our code of conduct, here's what you expect, here's our culture. Um, if you're just piecemealing everything, my my confidence in the company might go away a little bit. So I just eh, don't do it because once again, if it was a state that had paid sick leave and you're in a state that doesn't have it, it's not going to make sense. It's going to confuse people. It does happen quite often. Okay, let's go into some visual examples. This one is actually unique because it doesn't stick out at you because we talked about the at will. You have to read that first paragraph where it says each employee is an at will employee. This means that although we hope that your relationship with the company will be a long term one, you or the company may terminate this relationship for any time, for any reason, with or without notice. The reason why this fails the compliance aspect is because they have to be two separate paragraphs. If I did not read that, would you have noticed the at the end of sentence 2 where it says will be a long-term one, you or the company may terminate this relationship? Probably not because the company's name is so long, and that's why I used it to block that out. That's what draws your eye. I'm sure most of you have seen a pictographic version of somebody having a list of like a paragraph where the first letter and the last letter is correct, but the words in the middle are jumbled because the human brain will process that and still be able to read that. It's the same thing with when you have long monikers for associations for people. So if you're only associating me with you, it's very small, but the association with the company is very long. So I might skim that and only read the part for with the company may terminate this relationship for any time. They actually got in trouble for this because of that reason. And that's why I brought up the length of the two separate or two separate statements. This one is interesting. Um, you can see it at first, you're looking at it and you're like, okay, makes kind of sense. So this position on time is 11 to 11:15 a.m. Even though the position is listed, oh, I think the position was listed wrong. It should have probably been 11 a.m. to 7 p.m. Do you want to know what a labor attorney did with this policy? I'm sure that you can probably picture it too. Is well, what separates 11:15 from 11:16 besides 60 seconds? How did you decide that 11:15 was close enough to 11 a.m. that the employee would not be penalized? Subjective value. The other part of it is if you look at the chart, the first one is policy. If you're on time, there's no action. Why? Why is that in a chart? Did we feel like we needed to create a chart and we only had two things listed and then we thought, "Oh geez, we should list another one because two things listed on a chart is not a very good chart." The other part of it is you're telling somebody if they're late 3 times a week, that's the first time that they're going to have a write up. Because, hey, I can be late 2 times in a week. I'm just going to have a conversation. There's also no additional um consequences. It says at the top though before the chart, repeated lateness however will be addressed by management and may lead to further action if not corrected. But subjective, what am I going to go look to? I'm going to look to the chart. So if I'm constantly late 2 days a week, according to this chart, the only action is a conversation with HR and a manager. The other aspect is on below it, it says you have to notify your supervisor or human resources, and it says that you will be absent for emergencies only. What constitutes an emergency, right? You subjective. It's going to be based on someone's experiences. What is an emergency? It's a gray area. You don't want to have that in the handbook. Job classifications. So for this, they combine exempt and non-exempt in both versions of this. My issue with this, and what the law will say is this is not what's based for benefits and for certain states. So this has a full-time worker is 40 hours, part-time is less than 40 hours. Later on in the handbook, you would see that regular full-time employees were given benefits, regular part-time employees were not. So if I, according to this statement, if I worked 39 and a half hours regularly, I'm not considered a full-time employee. Different states have different requirements. Some states say 30 hours is full-time, some say 32, some say 35. But to say that you have to work a 40-hour work week is actually violating a labor law. And you want to make sure that that is not what they see when it's listed there. Do I have? Oh, here's the last one because this is one of the things that people include all the time. So this is the immigration policy, pretty standard. Two things with this. One, I don't know why you would include it in an employee handbook because this immigration law comes into play when you're hiring the person. The person that you're hiring should not see your handbook until after they've been onboarded and fully hired into the system. The other part of it, which you can see on this last statement down here, is to present the documents that establish identity and employment eligibility, such as a current valid driver's license and social security card or passport or birth certificate. You are actually not allowed to tell a new hire what to bring. That's why there's the page 2 of the I-9 documentation where you say, Sarah, um, as part of your onboarding, we will be doing the I-9. Here's the list of documents. When Sarah reads it, she knows she can bring one item from column A or one from B and C. The fact that this is in the handbook not only is a violation of the for a labor law, but it's also for the immigration. So you'd face 2 fines for this, for telling somebody how to present their documentation. So what that's why I said like some of these things are so small that you don't even know until you have the outside view of somebody else looking at it. Sorry, I don't know why I just got so heated at the end of it, but like I don't know why that mistake just bothered me so much. But Um, if there's any questions, please just put them in the chat and hopefully we can get you, like I said, I want you guys to have the guidance. So if there's something that's in your handbook that you want to ask a question, ask the question. If it's something where you might want another set of eyes for your handbook, please get a hold of Chris because Chris can, we can at least look at it for you and arrange that. Um, but is there any, I have the Q&A open. I didn't see anything. Chris, did you have anybody message you or?
So I've got, let's see, one, two, three, four, five, six. So I've got about 8 questions that have come in, just over. This has just been from social media or, from people that haven't been able to log in today.
Oh, okay.
Um, so I've got about 8 of them. We'll see how many of these we can get through. And some
Okay.
of these you've already answered, but we'll run through them.
Okay.
So first one, we're in 3 states. Do I have to have a handbook for each state?
Yes.
Okay.
Well, I mean, because there's different state laws. So, and
Right.
once again, it depends on the 3 states that you're in. Like I said, like harassment and discrimination, there's different protected classes for different states. And especially for that classification part for the full-time and the part-time, the states may require different things for what's considered full-time and part-time.
Okay. This one just came into the chat, so or into the Q&A. What would be the best way to ask for ID or social security numbers to do background and criminal checks before a job offer?
Can't. That's illegal.
All right. Okay.
You have to extend the offer before you have any of that information. So basically
Okay.
what you have to do is say, Sarah, this position is contingent upon a background check and drug screen, whatever it is. Am I okay to continue? You also, it has to be listed in the offer letter before they sign off on it. And there's a 24-hour window. So if I offer Sarah a job that's contingent upon a background check, I have to wait until Sarah signs and returns the offer. So if I sign and return it on a Wednesday, then Thursday, you can then send me the information to start doing my background check. Or DOV, like DOT, if you're doing a driver's license check, any of that type of stuff.
Okay,
The other
perfect.
part of it too, sorry, Chris, I know this is like nuance, but
No, you're good.
if you also, sometimes people will do background checks if people get promotions internally. That's actually a policy that you would want in the handbook also, is if you're provided a promotion that you would do this. Like you'll run another background check. Same thing with like reasonable suspicion policies. So if you have any type of suspicion testing, you would want that too.
Would a
Verbal
verbal
okay is
okay
not
work?
okay.
Okay.
Yeah, no, it is not.
All right. Let's see. The next one that I have. Do I need to include the obvious common sense stuff too? It seems like overkill.
It depends on what it is. Like what is the common sense stuff that you want to exclude? And is it something that you could find as a reason to terminate somebody? Then you definitely want to have it listed in the handbook.
Got it. Perfect. Oh, this is a good one. What happens if an employee refuses to sign the handbook?
You have to have a witness and then you would have the witness sign at the bottom that Sarah refuses to sign the employee handbook. And it's up to you because you can exercise at will at that time and state, well, at this time, we're going to go ahead and end the employment relationship.
Okay.
You're not going to tell them it's because they, you know what I mean? Like you won't say
Right.
the reason why we are terminating you today is because you did not sign this. That is not what you're going to say. You're just going to say we're exercising at will. So if they go to an employment attorney and the employment attorney says, well, why? And you have the documentation that just says, nope, we terminated Sarah following at will. That's what it says on her letter.
Got it. Okay. Um, okay, this one's an interesting one. How can we include language that covers disciplinary action for unexpected incidents? For example, sleeping on the job.
I mean, that would probably be part of job description. Well, sleeping on the job might be more safety related. So you could look for safety concerns and then you could look for job description details that would kind of go around it. Um, there is kind of like a template for standards of conduct that kind of cover quite a bit. You're looking for how to approach it appropriately, and document it the right way. So I think it's kind of like a two-part answer is like you want to have like the blanket statement of it, but the second part is you want to know then how to approach that employee with that disciplinary or corrective action. And you want to make sure it's very clear, right? Like, Sarah, in your position, it is not acceptable to be sleeping on the job. Do you understand that it's a safety concern? That type of thing, document it, and then just continue the progression from that point on.
All right. Let's see. So the next one that I have, um, what are the most common legal updates employers overlook when revising their handbook?
I don't know about the legal ones because typically they're pretty predominant in the news and on your state's Department of Labor, they will bring attention to that. I think that's a good one. What's the most common one that's not updated? Some of it might just be for optional policies and it might be the verbiage. Chris, I might send you an example of that so you can send it to somebody. It's
Okay,
really just like sometimes they'll change a legal requirement, but it's because they're changing the way they're categorizing something. Um, so an employer might say, oh, well, this law is basically the same. I'm not changing it. When in reality, you have to change it because of the verbiage. That's why there was a change.
got it. So a couple quick things from the chat. So Thank you, Ms. Sherry. So she said this was a very helpful webinar. Will the PowerPoint presentation be available for future reference?
Yeah, I can send it to you, Chris. Yep.
Perfect. Okay, that'll be great. And then just to kind of circle back to the background check one.
Hmm.
Um, so at will, can
Yep.
that be at any time during the
Yeah.
employment? If
Yeah.
there's a okay, so if there's a disciplinary issue with with that fact in to go through the process before exercising at will.
Yeah, I mean, so the way you're looking at that is if you do disciplinary procedures, you're hoping that the employee is aware, hey, my conduct is causing my job to be in jeopardy, which is basically a nicer way of saying you're coaching the person up or coaching them out. If at some point Sarah is very thick-headed and she's not processing the information, I recommend stating that you're going through with the at will part, right? And you're terminating because of that reason. Now, the employee still has a right to file for unemployment. When I file for unemployment, that's when you can use all of the information, right? Like if Sarah caused thousands of dollars in damage, if Sarah lost us a customer or a client because of her conduct, you do not need to show your cards to the employee. You can wait. If it's just, and this is kind of one of the things too, is like, do you fight your battle or are you okay with just paying unemployment? Because at some point too, you have to admit, and I've done this in my past as an HR director, is I've hired somebody for my HR team and they were not a good cultural fit. Their personality just clashed with everybody. And you kind of have to rise above the ego and then just say, it's not working out. We wish you the best in your future endeavors. I know that that person has the right to file unemployment. That's the point of at will, right? It gives that access. And I just have to be what decision makes the best sense for the company at that time. Um, but yes, it is okay to say, Sarah, like on the letterhead, because you always want to present documentation when you're terminating employment. It's okay to say, we are going to involuntarily terminate your employment relationship effective October 15th, your last pay, like, and then just list the parameters. If you feel like you have to list a reason, you can say we are just exercising our at will, but you don't have to list any reason when you terminate. I think people just try and be good human beings and they want people to know. Um, but that's just really you providing more information.
All right, perfect.
Sorry, Paul, did I answer that question for you? If not, you can always ask Chris and like we can have a conversation about it. If there's something that's like you're going through right now, we can certainly have a call to talk about it.
All right, I've got two more here
Okay.
from my online submissions. Let's see where to go. So quick, easy, simple one, I think. How often should we review and update the handbook?
I would at least do it annually.
Okay. And I'm going to assume that's to pick up anything, new that's changed, right? So whether it be a new set of holidays or whatever, right? So that's just and it doesn't have to be a complete overhaul, right? It's just can be something minor like that.
Yeah.
Okay. Last one. So when changes or updates are made to the handbook, does the employee need to sign it again or does the
Yes.
originals? Okay, got it. Those are all the questions that I have at least. Unless there are any more in the chat. Miss Sarah, I appreciate you very, very much
Oh, you're
for
welcome.
taking time out of your day. And I thank everyone that attended. We will make this available. And also if you have any further questions or want to have, a quick look at your handbook, please let me know. You can reach out to me. You also, Chris Thompson or Christy Sinclair, reach out to one of us, let us know so we can put you in touch with Sarah and her team. And that way we can at least get an assessment going there. Right. So as far as the handbook goes, did I say that right?
Yeah,
Okay. Perfect.
absolutely. I'm sending you the presentation right now too, so I don't forget.
You're the best. Okay.
Thanks, Chris.
All right. Thank you very much. I appreciate you. Thank you for your time, and maybe we'll do one of these again in the future.
Yeah, sounds good.
All
All
right.
right.
Thank you. Thanks, everyone.